And live.
The light came on that says live.
Oh, and we are live. Hi, this is Del Medina. I'm the CEO and co-founder of Avion Ventures, and this is another wonderful, super excited to have Sally Kay with us, version of Avion Tech School. So we're going to do a little Startup 101. But before we get into it, let me just tell you a little bit about Sally. She is currently a partner in the Emerging Companies Practice Group and is a member of the Cooley Business Department. She joined the firm in 1999. And she has great general business and corporate law practice representing both emerging and public companies in a variety of matters, including venture capital financing, public offerings, and SEC reporting and compliance. So one of the things that I love about Sally is that she's my own lawyer. She's Avion's lawyer, so full disclosure there. But also that you, Sally, are a very real person, and you like to keep it real because you want to see people succeed. I don't think that you take on clients unless you think that there is something there for them to succeed. And so I just want to get into it. First of all, let's talk a little bit about how you became a lawyer and what your own personal philosophy is about law.
Sure. So thank you for having me. I'm very excited to be here today. I always wanted to be a lawyer when I was about 8 years old. It's one of those things when you have high reading comprehension as a kid and all the adults say, you should be a lawyer. So I guess I just figured I should be a lawyer. And I liked watching lawyer shows on TV. Just not to age myself, but I was a big fan of Perry Mason.
Mm-hmm.
But over the course of time, I thought, well, I'll be a lawyer. And then you go to college and then you just don't want to go to any more school. So I took a little bit of a break, 13-year break between undergrad and law school. And then I went, okay, now it's really time for me to go become a lawyer. But the one kind of epiphany that I had in the process was that I didn't really want to be like Perry Mason because litigation seemed to me to be very adversarial all the time. And that was not appealing to me. I'm not much of an arguer. I can be a great advocate, but I'm not much of an arguer. And I didn't really like the aspect that in litigation you have winners and losers, which is really, I think, coupled with the business background that I have, what drove me to this specific area of practice of law, because this is really more about helping people build things and to be a part of a team. And even when you're in a situation ordinarily where things are perhaps adversarial to some degree, like you're helping people negotiate an investment, the people on the other side of that transaction are going to be on your team when it's over because they're going to be your investors. So it's not the same kind of adversarial nature. It really is just an advocacy thing so that you all come out to a place where you all feel good when it's over.
Great. And actually, I want to interject here that you actually come from a program management background. And so I think it's important in the work that you do with startups that you understand what it's like to actually build a product and to go about that process. So I'm going to interject with it. And so let's, now that we've established what you do and how you do it, let's talk a little bit about what are your top kind of thoughts that people should have as they're building out their startup, how they should incorporate, what's that process like? Let's just go through that a little bit.
Sure. So, it's always tricky, the question of when do we actually form an entity? And there are varying schools of thought on that and varying comfort levels of founders and individuals. But I think that the one thing that oftentimes precludes people from doing that right away is that they don't want to spend any money. I will, in self-interested fashion, I will direct you. We have a website called Cooley Go that is a web resource for entrepreneurs that is absolutely free, that will actually help you generate some very basic documents if you want to form a company and actually let you know where to file those things to do it. But the reason that you want to incorporate your company somewhat early in your process is because you want to be able to create a limitation of liability on the individuals. So when you're working by yourself and you're doing things and you're going out there and you're signing contracts, but you don't have a company, you are personally responsible for everything that you commit to. Once you have a company that's formed and you're signing documents on behalf of that entity, the entity is responsible and it takes away personal liability. So if, for example, you enter into a contract with a contractor individually where you were obligated to pay them a lot of money and you didn't for some reason, they can come after you personally to collect on that. If they enter into an agreement with a company, as long as there's no deception or bad acting in the process, they need to come after the company for the money, but you personally as the founder would not be responsible for paying the bill.
No, I think that's a really good point that you bring up. I've had this conversation recently with someone that's building out their team and all these things, and I'm like, how are you incorporated? And they weren't, and I was shocked by that. So let's talk a little bit about, so now that you are thinking about going through the incorporation process, what are some of the steps that you have to think about in terms of where to incorporate and how to incorporate? What's the difference between an LLC and an S Corp? Why do certain things have preferences for investors?
So, I think that the primary question that comes up is Delaware or California, or Delaware or other state in which I am resident. We generally will counsel people, in most cases, that Delaware is better, just because Delaware is basically, their business is setting up businesses. And so the laws around setting up businesses, the case law related to disputes in businesses, is very well established in Delaware. But even more important, I think, in Delaware is set up to process things because that's their business and that's how they make money. So as an example, if you want to file your certificate of incorporation in Delaware, you can pay a standard fee and probably still get it back within 24 to 48 hours. In California, if you want to file a certificate of incorporation, you pay a standard fee, and sometimes you wait 7 to 14 days, just because the state of California is very backed up, and that's not the primary business of the Secretary of State of California. And so we've found over the years that Delaware is just a lot faster and a lot less expensive in the long run in terms of saving you time. But there are oftentimes jurisdictional reasons to want to stay in California or your actually state of residency. So those are some things that you should probably evaluate. And there's lots of information on the internet about why one versus the other. Nevada has also gotten pretty popular as a place to incorporate, particularly if you're there, because it does have a lot of very similar protections to Delaware. So it's something that people, I think, are starting to look at, particularly because if they're resident in Nevada or they're planning to be resident in Nevada, the taxes are much lower in Nevada.
Great. And can you answer the question LLC versus S Corp versus C Corp just really quickly? I know there's a lot of information out there, but I just wanted to get your take on it.
Sure. So in the distinction between being a limited liability company versus a corporation of some form, I guess the general rule of thumb is that if you are expecting that you are going to take venture capital investment, I'd say 90% of those investors only invest in a corporation. So if you start as an LLC, then you'd have to convert to a corporation, which costs money and time. If you choose to form as a corporation, there's something with the IRS called an S election that you can make with the IRS. You need to do that within a certain period of time after you form the company. And when you file an S election, it allows you to basically get the tax benefits of being an LLC while still being a corporation, but only for a certain period of time. So you can be an S Corp for as long as you are not raising money, because investors won't invest in S Corps, so they want to invest in C Corps, because S corporations are only allowed to issue common stock. You can't issue any preferred stock in an S Corp. If you form as an LLC, or if you make an S election, you generally are not anticipating to have any revenue in the short term, probably, not looking to take investment in the short to mid-term. An LLC is treated differently for tax purposes. So an LLC can make distributions to its members, where a corporation does not ordinarily make distributions to its stockholders unless there's some kind of liquidity event. So there are tax benefits in an LLC too, especially if you have a business where you're expecting that you're going to experience losses for some period of time, because you can pass those losses on to the individual members and then they get the tax benefit of the losses. Okay. Also, I would say if you're a service business or a service provider and you're not looking to bring on a lot of employees, or you're not looking to provide equity to a number of employees, an LLC might work as well.
Great. So thank you for that primer. So let's get into a little bit about, okay, you've incorporated, you're moving along, you are ready to receive investment. What are some of the vehicles from a legal standpoint in which you come about doing that?
Sure. So there's lots of ways to take money. I think at the very initial stage, founders tend to put in their own money and try to kind of drag things along as far as they can to increase valuation and to just be really careful about who you're having to give up any share of equity to. It's really important that founders, if they're putting their own money into a company, that you kind of keep track of those things, because there are many circumstances in which you can repay yourself on that. So, I mean, if you're buying pens and papers and a photocopier and capital equipment by all means, keep receipts for all of those things, because at least in my view, that's stuff that you want to get paid back for at some point down the road. After you get outside your initial circle of founders of the company, most companies then kind of look to friends and family, which is a little bit tricky because your friends and family are not often accredited investors. And the reason that becomes problematic in some circumstances is that if you have ultimately stockholders who are not accredited investors, you need to jump through some additional hoops at various points in the company in order to be able to bring those people along with the rest of your stockholders. After you kind of have exhausted your friends, or if you have lots of friends that are high net worth individuals, which we like those kinds of friends, most companies generally do a convertible note financing. So basically what that is that is a promissory note. You promise to pay them X number of dollars and they give you some money. And that note will at some point in the future convert into stock of your company on terms that are to be negotiated and determined by a lead investor at some point in the future. The reason that note financings happen a lot in very early stage companies are kind of multifold. One, it's not a lot of documentation, so it can be done very quickly. And two, nobody has to establish a valuation for your company at that point. The equity that it will convert into is a series of stock that is to be determined, with terms to be determined and a valuation to be determined. And so nobody has to be responsible for setting a valuation. And it may be at a point in the company where it's too early to even determine what the value of the company is. So lenders or investors will lend you money that will convert into equity at some point in the future when somebody's in a better position to have determined what the company is worth.
So let's stop there about these convertible notes. How big of a document is this? How detailed is it?
The note itself is generally 3 pages long. I mean, it's pretty short. The shorter the better for the company. Sometimes you have some people who want to put some more terms in the note, but try to push back on some of those things. It depends. But mostly they're just general representations about the company, some terms about the amount of the note, when it's due, the terms on which it converts, the terms on which you might be in default under that note. So it's pretty basic. And also, we would advise that you would also do a note purchase agreement so that you have an umbrella document that binds all of your note holders under the same instrument, and so that you're not entering into separate notes with every single individual person. You'll still issue them a note, but it's part of this larger loan happening under the note purchase agreement. The biggest benefit to that is that if you want to amend any of the terms of those notes, you don't have to go back to every single individual note holder. So you have to go back to the people holding a majority of the outstanding money under that note purchase agreement to make any changes.
Great. So I think when we were talking earlier, which I found really interesting, is that you were saying the shorter the documents, the better off you are. And I think that too often people think that the longer the documents, the better off you are. So talk to me about why documents within Silicon Valley, and specifically in startup, are becoming shorter and shorter.
So there's lots of reasons for that. One, I think you run the risk when you have a really long document that somebody feels like they need to go get their lawyer to look at it. So, or they need, and especially in a corporation, it may become, if you have a strategic investor, for example, they have to run it by their legal. And if it's a big, long document, it'll just get stuck on a pile and they'll get to it eventually. So the shorter, the better. But I think there's a real trend here in the Valley to try to kind of de-lawyer a lot of documents so that you're not wrapping all of this legalese when it's not necessary, and trying to plain English is an expression the SEC came up with a long time ago. Plain English the documents so that anybody can pick them up and read what they say. And it's something that anybody can pick up and read as opposed to needing a lawyer to understand it. And it's just very clear and to the point without wrapping a lot of things around it. And I think we're seeing more and more that people are really interested in making docs as concise as they can be so that it doesn't impede timing and process for others.
Great. So let's finish you were going. So we were going convertible note. What's the next level of investment that someone like you would come along and you would be part of the legal strategy and team?
So the next investment is actually a priced round of financing where hopefully you're gonna get a term sheet from an investor or two to purchase stock in your company. Depending on how big of a note round you've raised, and how far along your business has gone. That's generally a Series seed financing, depending on how much money you're raising. Some people go right to a Series A financing. The nomenclature is really pretty arbitrary. You can call it Series Purple. You can call it Series 7. Call it whatever you want to. It's really more about what the terms are of that financing. And that's something that would be proposed in a term sheet from a prospective investor and negotiated pretty heavily. If it is a Series seed financing, those tend to be financings of $1 million, $2 million on top of usually whatever your notes are converting. There's actually a standard set of seed documents that most companies are using and most law firms use. You can look at those at seriesseed.org. Shows you kind of the basic documents in a seed financing. And those set out, the rights, preferences, and privileges of the stock that you're selling to the people in the financing. Your notes would also then convert into that round. The notes usually have some kind of discount in them to the next round, so they may convert at 80% the price that the new investors are paying. And it lays out all the terms. So in order to get people to be interested to give you money, they certainly want something back. And so in those terms, they may require, on a liquidation, they may require a preference, which means if you sell the company, they get their money back first before anybody else gets money. They may want that preference in multiple, so they get 1.5 times their money before anybody gets any money. They may want a board seat, ability to sit on your board for some period of time. And there's lots of other things that they can negotiate for.
Yeah, and that's where I think you come in also, because you're helping people craft this, put it together, and I think that's your expertise also. Like, one of the reasons why I would want to work with you under that circumstance is, like, you see a lot more of those deals than I could ever. Like, as a lawyer, you're constantly seeing those deals versus a startup founder might have gone through this once or twice before, but that's about it. Your ability to take a look at what's going on in the marketplace and say, look, this is what's going on right now, is a huge advantage for any startup founder.
It's absolutely true. And, it's very interesting because I think that founders tend to focus on the terms. And obviously we see a lot of terms. And we actually continue to plug the firm. But if you go to our website, we do post quarterly a report of all of the venture financing deals that we've done in the quarter and what those terms look like. For a seed, for an A, for a B, what they're kind of looking like on a percentage basis. The other thing is that we know the investors. And I think that when you're thinking about terms, you also want to be really thoughtful about who is this person or who is this fund that's brought me this term sheet, because they're going to be a long-term partner with you if they're your investor. And if you get a really bad vibe from them, it may not be somebody that you want sitting on your board or driving your business with you. So you really are looking not just for an investor, but for a partner. Unless you're to a point of absolute desperation where you just can't find money from anybody else and this is the only money that's out there, I think it's really, really important to, A, go with your gut and really get a sense of who those people are, but to also, weed them out through people like us. Because we, very often, and I think most lawyers do, will send around an email to everybody that they know and says, has anybody got, Joe Smith sitting on their board? And what is he like as a board member? Or what are they like as an investor? Or what are they like as a partner? And we can get all of that recon for you so that you're not just blindly taking money from a fund that you don't know anything about.
Yeah, great. Well, thank you so much, Shelly. We have a couple minutes left. I don't know if you'd like to add anything at this point about your work and your passion. I mean, I know this for a fact. You work really hard, and you also want to make it as fun as possible, because it's not always an easy job. And that's one of the things that I love and admire about you, is that regardless when I call you, you're always like, I'm plugging along. And so in some ways I think of you sometimes as one more person with a startup, because you have your own practice and you're managing your own clients within a firm, but you got to keep things going. So could you give us 1 or 2 tips of what helps you keep going?
Sure. So, one of the reasons that I really have my practice, when I first started here, I was doing probably 50-50 startup companies and public companies. And the public companies that I still work with are clients that were mine when they were startup companies. So I've been with them for a very long time. And I think the thing that primarily keeps me going is that I actually feel like I am part of the team, that we are building something together, and we've helped on our end for the company and helping them navigate through what they're going through, what lies ahead, and trying to help them make good decisions so that their business can be successful. But to your point, life is very short, right? And so none of us like to work with people that we don't like. And back to the point of when you're thinking about picking a lawyer, when you're thinking about picking an investor, when you're thinking about adding people to your team, they could be the smartest, best, richest people in the whole world. But if you just don't feel comfortable with them, I think you need to be intuitive about where that feels in your gut, because it may not be the best choice for you. And I'm that way too. I mean, life is too short, and I may not, I may miss the next Google if it's a group of people that I just don't really like, because if I'm going to be part of your team, I really want to work with you and like you as human beings, which I think is really important for all of us. And I think that people tend to not remember that lawyers are people too. Or people think about lawyers as you see on TV, which we're generally not. And not just something that costs you money, but maybe somebody that can help you build your business in a meaningful way and help you avoid the pitfalls that are out there, that we know are out there, that you may not be able to anticipate.
Great. Well, thank you so much, Sally, for your time and expertise and willingness to share it. We've been speaking with Sally Kay. She's one of the partners over at Cooley, and as I said, she's also a Avion Ventures lawyer. I'm a huge, huge fan. I hope you've enjoyed this video, and we will be in touch. Take care.
Thank you.
Bye.